Well, thanks and ever thanks to this law faculty and the Distinguished Speakers Committee for this opportunity to share with you some of my research on structural discrimination in the context of polygamy. Let me proceed by explaining how structural discrimination is based upon stereotypes. Then I'll proceed to look at how polygamy is based on stereotypical perceptions of women. And finally, I'll share some of the findings of my research on trends in international legal developments regarding the elimination of polygamy. So to start with structural discrimination requires understanding how gender subordination is rooted in, for instance, our religions, our cultures, and in our habits of thinking, that is, in our traditions. Like most forms of discrimination, gender discrimination is socially constructed, but its construction varies from other forms of discrimination. For starters, gender differentials are thought to be acceptable when they are based upon traditions that are regarded as natural. My argument today is that the elimination of structural discrimination requires that societies to address their restrictive gender stereotypes that are deeply rooted in our myths, our laws, and our ways of thinking, and in our traditions more generally. There are many forms of gender stereotypes that are embedded in these traditions. Sex stereotypes concern generalizations about women and men's physical, emotional, and cognitive capacities. Sexual stereotypes concern those characteristics or qualities that play a role in sexual attraction or desire, or, for example, sexual objectification and exploitation. Sex role stereotypes, in contrast to sex and sexual stereotypes, ascribe to women and men different roles that are perceived as culturally appropriate to each of them, based upon prevailing gender ideologies. These stereotypes often combine with other characteristics, such as marital status, to create generalizations, in this case today, about polygamous women. So, turning to how structural discrimination is embedded in the practice of polygamy, one could say that polygamy allows us to address whether gender stereotypes of polygamous women is a form of structural discrimination that requires elimination. The reference case, now pending in the Supreme Court of British Columbia, addresses whether the state is permitted to use criminal law to prohibit polygamy. The purpose of this talk is not to argue one way or another with regard to the reference case. Rather, I want to explore with you how some selected countries are beginning to address gender stereotyping in polygamous families as structural discrimination. This exploration is based upon some of the insights that I gained from serving as an expert witness on state obligations to eliminate polygyny under international human rights law for the Attorney General of Canada in the reference case. The Attorney General commissioned this report because, as you know, international human rights law informs our charter interpretation. The report that I did in 2010 is based upon an earlier report that I did for the Attorney General in 2006 with a former student, Lisa Kelly, who I continue to do research with on this very issue. So before proceeding with polygyny, let me explain that term. Polygyny is the practice of one man marrying many wives, and not vice versa, and hence the title of this report. It's not that international law doesn't address one man marrying many wives, but it predominantly addresses polygyny, one man marrying many wives. and not vice versa. So by now, you might be asking, how does the practice of polygyny perpetuate gender stereotypes? Religious and customary laws that permit polygyny continue to rely on sex differences as a central axis in the distribution of marital rights and obligations. In doing so, they rely on and perpetuate gender stereotypes hostile to women's equality that have long been rejected in many laws. The content of such gender stereotypes can vary according to the particular legal system under which polygyny continues to be practiced. In general, however, the dominant stereotype is a sex role stereotype. That is, women in polygynous unions have to fulfill specific sexual roles, that of a wife, that of a procreator, and that of a mother. Each of these roles, including the sexual component of wife, supports and reinforces each other. They marked polygamous married women as different types of persons from men. This is our argument. Historically, the common law of coverture also distributed marital rights and obligations unequally according to sex, in favor of a husband's control of their wives' property. Persons of different sex were understood to be different types of persons under the laws of marriage. A wife was understood to be subsumed within her husband's legal personality under his family name, and the children of that marriage were understood to fall under the near complete custodial power of the father. So that's sex role stereotypes. Sex stereotypes of feminine dependence, fragility, and commercial naivete were constructed in opposition to stereotypes of masculine, protective, breadwinning, and financial acumen. An increasing number of family laws regulating marriage and cohabitation have since moved away from the expressly sex-based construction of family relations. Spousal rights and obligations in an increasing number of jurisdictions now adopt both parties equally, now apply to both parties equally regardless of sex. The legal adoption of same-sex marriage has removed the notion of sex differences as essential to marriage altogether. So depending on the relevant customary or religious system that retains polygyny as an acceptable institution, it may be that the role of, quote, wife implies continuous sexual availability to one's husband. That is, sexual stereotypes of polygynous wives is to be continuously available to her husband. Now, the inherent wrong of these sex role, sex, and sexual stereotypes is that it prohibits polygynous women from making or fairly negotiating her own life plan, their own life plans, in ways that are equal to their husband's ability to determine his own life course. Now let me look just briefly at some of the findings of the report that we did for the AG in regard to trends in international and comparative law with regard to polygamy. There was a distinct trend that we found in terms of outright prohibition of polygamy over the past 5 to 10 years. Interestingly, there was also a distinct trend in increasing trend in additional restrictions on polygamy. So while those states that don't prohibit it altogether were certainly moving to restrict it in certain ways. And fascinatingly, there were developments in immigration laws and policies with regard to polygyny, which was something completely new, which we hadn't even thought that existed. So let me start first with some of the trends with regard to prohibition that we found in the concluding observations of reports of state parties to human rights committees. Now, we looked at the Human Rights Committee, the committee that monitors the implementation of the International Covenant on Civil and Political Rights. We looked at the trends in the International Covenant on Economic, Social, and Cultural Rights, and also the Convention on the Rights of the Child. But I really want to focus today on the trends in the regime of the Convention on the Elimination of All Forms of Discrimination Against Women. Because that convention has a very unique provision requiring states to eliminate prejudices and customary and all other practices that are based upon concepts of inferiority or superiority of either of the sexes or in stereotype roles for men and women. I'm quoting there. So in applying this mandate to eliminate prejudices and customary and all other practices that are based upon the idea of stereotype roles for men and women, the committee, the Women's Committee that's set up under this treaty regime, has consistently articulated the need to eliminate cultural, customary, and legal norms that perpetuate stereotypes. The committee views polygyny as a harmful traditional practice and encourages states to dismantle the traditions, customs, and stereotypes of women's roles in the family that contribute to the perpetuation of polygyny. And these were found in the concluding observations of the committee on the state reports, on the reports of states from many different countries that were party to the Women's Convention. So that's in terms of what's happening in international law. Let me turn now to what's happening in terms of comparative constitutional law. And there were three distinct trends that we found in terms of the rationale that courts use to prohibit polygyny. The first rationale was to protect monogamy, and in some countries this was explicitly articulated as protecting monogamy as the Christian form of marriage. The second rationale was to prevent fraud on the state, because, as you know, polygynous women marry, but then they present themselves as single moms to enable them to get welfare benefits for themselves and their children. The third and most recent rationale, which has only emerged in the past 5 years, is to promote women's dignity and equality. And here, in the interest of time, I just want to draw on two fascinating constitutional court decisions. A 2007 decision from Indonesia and a 2009 decision from South Africa. So essentially, the question for these courts, and for many courts, and there's several cases now pending before courts, is there something essential to our dignity that requires the state to arrange the legal structure of family formation so that it is, at least in terms of the legal structure of family formation, equal for women and men? So with the Indonesian, in both of these courts, both of these constitutional courts answered that question in the affirmative. Yes, there is something unique and distinctive about intimate sexual relations that one forms for, allegedly for life. So with the Indonesian decision from its constitutional court, this was a challenge to a law that required a man to have the authorization of his first wife if he were to take a second wife. The Indonesian constitutional court held that these limits, that is, a man getting permission of his first wife if he were to take a second, were constitutional and compliant with Islam. In so ruling, they explained that, here I'm quoting, the The wife's consent is required because it is closely related to the wife's position as an equal partner and as a legal subject in marriage whose dignity and status must be respected. This is the Indonesian Constitutional Court. Indonesia is the largest Islamic country in the world. South Africa, where, as I'm sure you know, the president has many, many wives, the South African president has many wives, ruled in 2009 that Muslim women in polygynous marriages should be able to inherit equally with Muslim women in monogamous marriages and with non-Muslim women, despite provisions of the South African In-State Succession Act. In deciding the legal effect of this act, the court explained, and here again I'm quoting, by discriminating against women in polygynous Muslim marriages on the grounds of religion, gender, and marital status, the act clearly reinforces a pattern of stereotyping and patriarchal practices that relegates women in these marriages to being unworthy of protection. Needless to say, by so discriminating against those women, the provisions in the Act conflict with the principle of gender equality, which the Constitution tries to achieve. That cannot and ought not be countenanced in a society that is based upon democratic values, social justice, and fundamental human rights, end quote. So these decisions begin to provide constitutional rationales using equality and dignity to the limitations on polygamy. A South African colleague said to me after this decision came out, this is the slow death of polygyny because it's making it more expensive for the man to take many wives. So let me turn finally to the immigration laws and policies and the findings of our report in this context. So the trend in immigration laws and policies in countries committed to monogamy is to prohibit the entry of polygamous families. In the immigration laws of Canada and the UK, for instance, polygyny is a bar to immigration. The approaches these two countries take to ensure that only monogamous families immigrate varies and can have important implications for the perpetuation of harmful stereotypes of immigrant women. As of 2006, because of a visionary person in the Department of Justice, Canada now provides that only the first marriage may be potentially recognized for immigration purposes. Canada requires that the sponsoring spouse provide evidence of lawful divorce of any subsequent marriages. In contrast, and this I find fascinating, the UK allows the husband to determine which of his wives he will bring. In the UK, it's the order in which the polygamous wives come to the UK for settlement, not the order in which they married the husband. That is the decisive factor for determining which wife is recognized as the lawful spouse for immigration purposes. So the husband can bring the second wife without even showing that he's divorced the first. The UK approach gives almost absolute power to the husband in polygynous marriages, who is the citizen or permanent resident in a destination country. It permits the husband to determine not only the immigration status of each wife, but where each wife will live, whether that wife can live and have the custody of her children, and whether that wife can work if she is in the UK. These are the very powers bestowed upon a husband under the doctrine of coverture. The UK immigration laws have thereby failed to break the links of their historical stereotyping. That is, much of the gender bias in immigration law in the UK is a legacy of century-old doctrine of coverture, under which women's legal assistance merged with that of her husband upon marriage. So let me conclude and leave you with this point. Conditions for social stratification and subordination of women exist when wrongful gender stereotypes are pervasive across sectors, the family sector, the education sector, the employment sector, and are socially persistent over time. In understanding how restrictive stereotypes of polygynous wives are pervasive and persistent in our laws governing family structure or in our immigration laws, one is better equipped to address the structural forms of discrimination found in gender hierarchies in societies more generally. Thank you.